Thank you for joining us here on Law and You this week. I'm Uyag Mofwegbe. It's been an interesting 7 days between the last time we're here today. So we're going to look at something that is very pivotal to the rule of law, to the judicial system, of course, to the legal system as well. Two issues bundled into one. The issue of jurisdiction and then hierarchy of courts. Most times you hear about the magistrate courts, the customary courts. You hear about things like the high courts, the federal high courts in particular. And they hear about things like the appeal court and then the Supreme Court, which is where people and, of course, institutions usually find closure to whatever matter it is, at least in the case of Nigeria, for example, and other jurisdictions. On the program today, we want to pay attention to these dynamics. Several technicalities embedded into this conversation. But the good thing is we have a lawyer who is going to help us spread out the conversation and then put a pin on each of the elements involved in these issues. We're back shortly after this break to help you make sense of it this week on Law and You. Stay with me. On the program this week, I'm joined by a lawyer who has a handle on this discussion, and then he's going to help us beat both context and, of course, perspectives into this issue in such a way that the average viewer will be able to put a finger on exactly what the differences are between these jurisdictions and then the issues around the hierarchy of courts as far as Nigeria is concerned. Barrister Matthias Obayiwana, of course, is a legal practitioner, and then he's going to help us make sense of this conversation. It's always a pleasure to have you on the program here on Law and You.
Yeah.
I want us to talk about the issue of hierarchy of courts. People are wondering, for example, what exactly are the matters that inform which court you go to per time? We have seen some cases that go straight to the Federal High Court in Abuja, and you're wondering, hold on a second, this thing happened in Abia State. How did these gentlemen find themselves in Abuja in this matter? What are the dynamics that we need to understand?
Okay, for generally talking about hierarchy of courts, we have two major categories.
Okay.
We have the Court of Records, which is considered to be the superior court, and then we have which provisions are made for the creation of such courts in the Constitution. We have the rather inferior courts, which are courts created by law also of the various states. So in these two categories, the inferior courts are looking at the district customary courts, the area customary courts, the magistrate courts. You know, these are the mobile courts. These are courts that are creation by law made by the various states. Now, the Court of Records, as contained in the Constitution, starting from the top, we have the Supreme Court, which is the ultimate court in this country. We have the Court of Appeal, which has appellate divisions across Nigeria. We have the Federal High Court, which also have divisions across Nigeria. We have the High Court of the FCT. We have the High Court of the various states in Nigeria. We have the National Industrial Court, which is a special court created for labor matters. We have the Customary Court of Appeal, which is the court that handles appeals from the customary courts, on traditional and customary issues. We also have the Sharia Court of Appeal. The Sharia Court is like the customary court of the Islamic,
essentially in the northern part of the country.
Part of Nigeria, yes. So we have the Sharia Court of Appeal. These are all courts of records. We also have the tribunals. The Election Petition Tribunal is also a creation of the Constitution. So
more like, if you like, ad hoc courts.
The specialized court, yes, to handle special issues. Like I told you about the National Industrial Court.
Right.
So you have the Election Petition Tribunal. So these are all courts of records. And in this hierarchy, the appeals flows from the lower court to the higher court.
Okay.
So when there's a decision given by the lower court, you're not satisfied, the appeal goes to the higher court. If you're looking at the inferior court now, the magistrate court, the customary court, district court, whatever appeals arises from all of that goes to the high court. Then the Sharia Court of Appeal, Customary Court of Appeal, High Court, National Industrial Court, Federal High Court, Election Petition Tribunal, all of this, appeals from this area goes to the Court of Appeal. And then from the Court of Appeal, appeals from there go to the Supreme Court, which is the highest court of the land.
I want to look at...
That's how the court, they are all
there's a level of curiosity with all of these things. People are wondering, how does it happen that a matter is already in front of a judge, and then at some point into the hearing of that matter, and you hear the judge say, well, I do not have jurisdiction to hear this matter. Yes. Therefore, we are reverting to the Director of Public Prosecution. So let's wait for advice from the DPP. You're wondering, between the litigants and the judge, how do we miss not knowing that this court in particular does not have jurisdiction?
Well, there are a number of issues that plays out in terms of issue of jurisdiction of the court. Okay. The jurisdiction of the court is a creation of law.
Of course.
The law by itself, the law that sets up the court has specified the kind of matters that can be handled by that court. That's what we call subject matter jurisdiction.
Okay.
Subject matter jurisdiction. So the kind of matter that can be handled by that particular court, they are contained in the law that created it. So for any lawyer who's bringing the matter to court, you must be sure to look at the nature of case you are bringing, the subject matter of the case you are bringing to court, and look at the law that creates it, and look at which court can handle such a matter.
Right.
Like we take, for example, now in those states just recently, the private property protection law was amended, to remove the jurisdiction of the magistrate courts to try matters arising from encroachment of land, criminal matters arising from encroachment of land or land grabbing. It has been vested now only in the High Court. Now, in the light of that provision, you cannot have an issue arising from encroachment of land, a criminal matter arising from encroachment of land, you will take it to a magistrate court or any other court.
That will be a fundamental error.
Exactly. So the subject matter, they have told you by the law that created it, which is the PPP law, by, for example, the recent one being made in Edo State, that law has given jurisdiction only to the High Court to determine such matters. So you can see a subject matter jurisdiction playing out. If you take it to another court, they will tell you that they don't have jurisdiction. Right. Take it to the court created for it, for such subject matter. If you're having labor-related matters, it used to be done by the High Court until they amended the Constitution and said it should be done by only National Industrial Court. If you take it to the High Court and the court looks at the subject matter you have brought is labor-related, they will tell you, no, the matters, I don't have jurisdiction. Take it to the other court that has jurisdiction. So subject matter jurisdiction is one basic factor of jurisdiction. We also have other factors of jurisdiction that will do with the competence, of the suit that you have brought. Okay. If you bring an action to court without following due process, because the law, the civil proceedings or civil procedure rules provide for how you can approach the court. If you approach the court otherwise than has provided by the rules, it appears that you are not follow due process to bring it. Any matter that will be brought to court without following due process, the court does not have the jurisdiction to try that matter. It has to do with the competence of the suit by itself. That is another issue of jurisdiction. We also have issue of jurisdiction as to the constitution of the suit. If you have parties before court, you can only have parties before court who are natural human beings, human beings like you and I. You also have artificial persons in bodies that is incorporated. You also have bodies created by statute, like there are certain offices created by statute. These are bodies recognized by law to bring action to court. Maybe
public institutions, for example.
Exactly. So if you are bringing an action to court, you are bringing an action against some other person that is not recognized by law. For example, now a company that is incorporated is an artificial person. It can sue and can be sued. If you bring a company that is not incorporated, just have an assembly, business thing, whatever thing you call it, it has no semblance of legality.
Yeah, it's not recognized by law.
Exactly. If you bring such a party before court, or that person brings an action to court, they can say the court does not have jurisdiction to try the matter because why? The party is not competent. It's not a legal personality, it cannot bring an action to court. So all of these all touch on the issue of jurisdiction. Yeah. Then you mentioned earlier the issue of territorial jurisdiction. It's another issue of jurisdiction. If a matter happens in Edo State, for example, you cannot, or maybe yes, you cannot go and bring an action really for land. You cannot go and bring an action in Lagos State to come and try issue that have to do with that's land related.
In Benin, in Edo State.
In Edo State. So such a court in Lagos State would not have jurisdiction to try such, because the issue of the territory, where did this matter happen? Again, it was also recognized the fact that the High Court, for example, in Edo State is one. We have divisions: Abudu Division, Okada Division, Benin Division, Igobazuwa Division, Urome Division, and the rest of it. All these divisions are for convenience sake. But if proximity, yes. If you check the rules, they tell you that if you bring a matter that ought to have been done in another territorial jurisdiction, if you bring it to another court, if you object to it, the court can transfer it to the appropriate division. But whatever has happened before that particular court will not be nullified. Okay. So if you don't mind, the matter can continue in the particular court, because the High Court is one. The High Court in Edo State is one. The same thing happens for the Federal High Court. So that's why you are surprised that a matter happens in Abuja, they now go to Federal High Court, Abia. You know, of course, the issue of the territorial jurisdiction is there, but like I keep saying, it's for convenience sake. Okay. That is okay, where you can go here, you can go there, because it is one Federal High Court. We don't have two Federal High Courts in Nigeria. Right. It's one state or federal. Exactly. You have only one. And then you now have divisions created out of it. So if you can go to the nearest division to you based on forum convenience, based on residence of the parties, proximity of where the matter has occurred, and all of that. Yeah. You know, so all of this, any of the Federal High Court can hear such a matter. The same thing for the Court of Appeal. If a matter happens in Benin, ordinarily you should file your appeal to the nearest court, maybe Court of Appeal, Benin Division. But what if I do not mind distance and I decide to go to as far as Calabar, as long as it's within the same as it were? Yes, the court may query you. Why did you leave? What's your reason for leaving? Much closer to you. Closer to you. Why you come bother us all the way here? You are dragging the parties to come to. There were cases that people took to Enugu. For example, there's a matter I was doing that occurs from Professor Benin here, and then the appeal went to Enugu. Court of Appeal Enugu, and you have the Court of Appeal Benin. So by the time the appeal went through the process and it was eventually struck for incompetence, you know, and the court queried the lawyers, why did you come to Enugu? You could have gone to Benin. You know, so it doesn't matter that the court may not close its eyes to the issues you have brought, but they'll be quick to remind you that you could have gone to the nearest division. The reason I asked that question is that we had a case from last year in the heat of the campaign leading to the governorship election 2020 in those states, where a particular aspirant had taken a case from Benin to Port Harcourt, and he got judgment in his favor, for example. In my head, as a non-lawyer, for instance, I was wondering, I mean, could he not have filed that same case in Benin? But I think you have done justice to that. But before we take a break, I want you to talk about the issue of coordinate jurisdiction. I think people who are not as lettered, so to speak, as yourself, may not understand exactly what the technicality is. What do lawyers mean when they talk about coordinate jurisdiction? Well, when you talk about coordinate jurisdiction, talking about the courts that are of the same level, same ranking. The same ranking. Now, the High Court of Edo State is on the same ranking with the Federal High Courts. Okay. It's on the same ranking with the National Industrial Courts. You know, the same ranking with the High Court of the FCT. So these are court of coordinate jurisdiction. Right. So one cannot sit on appeal over the other. You cannot have a decision given by the High Court of Edo State. The High Court of the FCT is sitting on appeal over that matter. It cannot. Does not have the power to do so. Only the Court of Appeal can look at such a matter. Okay. A higher court. A higher court. The same thing goes with the Sharia Court of Appeal and Customary Court of Appeal. It used to be in operation in Edo State. It was scrapped during a Shomole's era. You know, the Shomole's era. So we no longer have a Customary Court of Appeal in Edo State. All of these courts, they have the same, they have coordinate jurisdiction because appeals from them can go as of right to the Court of Appeal. Let's talk about just the same level. Yeah, one more issue, quite frankly, the issue of the disparity between the kind of legal system, or if you like, judicial system we practice in the southern part of the country vis-a-vis the one that's, as it were, prevalent in the northern part of the country. You talk of Sharia essentially in the north, from Abuja, I mean, from Niger State and beyond, for example. Over here is a different thing. I've heard lawyers talk about things like the penal code and so on and so forth. Walk me through that quickly. Well, I don't see the need for that dichotomy, but it exists. The penal code takes into consideration the peculiarity of people in the north, of the
religious,
Islamic
socio-cultural elements.
Exactly. Whereas under the Constitution, we do not recognize any religion as a state religion.
Okay.
But it appears to be giving credence to a state religion, because we still have persons in the north who are not of any religious inclination.
Yeah.
They are not Muslims, they are not Christians.
Maybe even traditional worshippers.
Yes, So now why would you not create a special legal system for certain persons in the north if the Constitution says that you cannot adopt a state religion? Right. Oh, this one is now a penal code. And every matter that happens here, they take into consideration the Islamic faith. And the people from Islamic faith and
you can't drink beer, for example,
exactly, and all of that. So they are all contained therein, and then you must not comply. If you are a northerner and you are not of the same faith, Sharia law will hold against you. All of that, you are just, it's a contradiction of what is in the Constitution that we cannot adopt a state. We are a secular state.
Which means largely the Constitution is in principle rather than in practice, because we understand that the Constitution ideally should be the ground number, as lawyers like yourself say.
So having a penal code, a special dispensation for criminal matters in the north, different from the criminal code in the south, there's no need for it. As far as my view, I believe that they should have a universal application, the same law.
Right.
If you are in Nigeria, the same law should operate. Nothing takes away from having a particular laws for the various states. But if you have a law in the Criminal Code of the Federation, it should operate across board.
Okay.
While having a penal code here, having a criminal code there, you must do it in such a way that you don't adopt a state religion, because the Sharia, with all due respect to our Muslim faithful, the Sharia law, for me, is more of a religious law. So if I live in the north, by our constitution we can live in any part of the country. If I live in the north and I'm into hoteling business, you can find people coming with the hijab, going to enforce Sharia law. They will come to your hotel and seal out the hotel, arrest people and see you are drinking.
And even prosecute them.
Yeah, you are selling alcohol. You are doing that, and that because of the Islamic faith. If you say the customary law of the people, that the Sharia, the customary law of the north, I would doubt, because there are many northerners who are not of the Sharia faith, who are not of the Islamic faith. If you are a secular nation, we don't have any state religion we have adopted. It should allow the same law universally, to operate across board.
I guess we can only hope that happens going forward, even though we're not so sure how it's going to pan out. But at this point, we're going to take a quick break, and when we return, we'll talk some more with Barrister Matthias Obayiwana. Stay with us. So I was going to ask you this about politicians. Somehow politicians find their way into every conversation, including the law, like we're discussing right now. There are people who have said, well, politicians exploit, for want of better words, the issue of jurisdiction to buy time, especially when it has to do with maybe pre- and post-election issues, for example. And there are those who have also pointed accusing figures at lawyers like yourself. They say lawyers aid politicians to use jurisdiction as a factor or principle, if you like, to buy time and then gain some advantage with regards to their political ambition and so on and so forth. I'm not going to ask you whether that's true or not. I'm going to only say, to what extent does that have an implication for our development as a country and for the integrity of the law as we know it?
Yes. Yeah. The law always is made to cure mischief. These are some of the mischiefs.
All right.
Yes, you cannot take from me that some lawyers do buy time with issue of jurisdiction. But issue of jurisdiction is the life wire. It's like you are placing something on nothing.
On nothing, yeah. And you cannot
and expect
something on nothing.
It can't stand. So if the court has no jurisdiction, it is necessary that issue raised very early enough in the proceedings. Don't wait till late. Raise it very early, and when it is raised, it is for the court to resolve that issue quickly. Now, for election petition matters, pre-election, post-election, and all of that, some of the courts, they have devised the law. They have brought some improvement in the law to devise a means of shutting out persons who want to delay the issue of jurisdiction. So what the disciplinary say by the rules is that if you have an issue of jurisdiction to raise, even in the fundamental right action, if you have an issue of jurisdiction to raise it within your defense.
Okay.
Somebody has brought an action to court, you want to challenge jurisdiction. Raise it within your defense. And then once you raise it within your defense, still go ahead and defend the entire action if the court, want to have the patience to listen to everybody. The court will hear everything out, and then in resolving the issues, the court will resolve first and foremost the issue of jurisdiction raised. Even in appeals, you cannot just raise an issue of jurisdiction and rest there. No. If you are defending an appeal, you raise an issue of jurisdiction. Raise it first. You file your notice and serve your colleague. You raise it first, the first paragraph of your brief, and you notify the court that you have raised an issue of jurisdiction. You will be quick to notify the court before the appeal is taken. Because if you don't raise it early enough, you can no longer argue that issue. So you raise it early enough. My lord, I have raised an issue of jurisdiction. I have filed a notice my notice of objection, and I served. And I have raised this issue in the first few pages of my respondent brief. So you notify the court. The court will take note of that you have raised that issue, and then the court cannot give a direction. Either the appellant will adopt his appeal first, then in your argument of your response, you adopt your own argument raising your issue of jurisdiction. Or they may ask you to argue that issue first before the appellant will raise the issue, depending on the direction of the court. But must be quick to mention it to court before the appellant will move to argue his appeal to say, I have raised an issue of jurisdiction. The same thing applies to the lower court. Raise it early enough. So when you raise that issue, then you now also bring your argument, in defense of your client in one fell swoop. When the court decides on the matter, the court will resolve the issue of jurisdiction first. Okay. If the court resolves that issue in your favor and find that the court does not have jurisdiction, there's no point belaboring themselves in raising the main other issues. The court will go ahead and dismiss. But in election petition matters, the court will still go ahead and resolve the other issue to save time, because they may likely appeal and get that decision. So if you resolve the issue of jurisdiction and it goes on appeal, and then the court now resolve that issue and send it back again to the tribunal to come and resolve this, the main issue, it will be time wasted. So the court will resolve the issue of jurisdiction and decide on it until go ahead, assuming without considering that the court had jurisdiction. Let us go to the merit of the main case. The court will now still go ahead and resolve the merit of the main case either way. So that by the time you go on appeal, the appellate court can look at the issues together, so like a total package. Exactly. So that provision will be brought in to cure that mischief, so that the idea of just raising only issue of jurisdiction and leaving the main issue behind. Then by the time you now finish, you take all that issue of jurisdiction, go to the Supreme Court, and then you now come back. Maybe one way or the other, it's either it's your favor, it's not your favor. Say, okay, now go back, now go and try the main issue. After many years, maybe after 3, 4, 5 years, you are not coming back to
it is counterintuitive.
Exactly. So that's why now they say, do everything at once. Raise the issue of jurisdiction, defend the matter on your own. At the end of the day, when they are deciding, they decide on that issue of jurisdiction first before resolving the main issue. So that mischief has been taken care of.
One last question before we're done altogether is, just like where we started from, we're seeing matters get to court and then the judge says, I don't have jurisdiction. Meanwhile, we revert to the DPP for advice. So until the DPP reverts or gets back to us, we're here stuck. In the meantime, in most cases, the accused person or the defendant, if you like, is remanded. How do you address that? Because in some cases, we're also saying that the defendant is eventually discharged and acquitted. So that pain, that trauma the person suffered in between, in terms of detention, in terms of remand, for example, I mean, he has taken the brunt. How does he get redressed for that?
Yes, this is in the area of criminal jurisprudence.
Exactly.
Yes, I quite appreciate the fact. It used to be, before the advent of the Administration of Criminal Justice Law, and people will bring a matter before, I bring somebody before a court that has no jurisdiction. Right. For example, matters of armed robbery and the rest, by the law that created the court, that also created the offense, they have specified which court can try such matters. Yeah. So that's what we call subject matter jurisdiction that we talked about earlier. Right. So now, if you have a matter that has to do with armed robbery or murder, and you know that the magistrate court does not have jurisdiction to try
it, you took it there,
but only the high court there, and yet you took it there. You took it there, and then they now ask for a remand the person pending when the opinion comes from the DPP. And sometimes the opinion don't come early, and people are not languishing there and not waiting trial for a long while until the opinion comes. So by reason of all that, the law was made to cure that mischief. All right. The Administration of Criminal Justice Law came into being to say, now, don't carry...
That's since 2015, right?
Yes. Don't take any person before any court that has no jurisdiction. If you have any matter with any person, maybe perhaps you need time to complete your investigation, or you need time for the DPP to look at the file and render an opinion. You don't want to keep the suspect in your custody for too long. Apply to the court. Right. To ask for what we call a remand proceedings. Okay. Remand proceedings. Bring it to the court that has jurisdiction, to the high court.
I've had a great time having this discussion with you, incidentally. Of course, as always, Barrister Matthias Obayiwana has brought brilliance and expertise to this conversation this week on Law and You. We deeply appreciate your time with us.
Thank you.
This is what we're drawing the curtains on the program this week. Thank you for watching. I'm Uyag Mofwegbe. The coverage on ITV continues. Enjoy the rest of your day.